A lot of service credit and service level regimes can be quite burdensome on the customer to administer. So you'll have to consider, obviously from the customer's perspective, how keen you are to have a complex service level or service credit regime, because it may result in payments every month or every quarter. And if they're relatively small amounts, how willing are you to take on the burden and the process of collecting those amounts? Something else to consider is whether or not the supplier should have the right to earn back the service credits. And some approaches to service levels and service credits do include an earn back concept. I think it's become increasingly concept over the last few years that suppliers be given the chance to earn back the right, if you like, avoid having to pay service credits or have their payments reduced for poor performance if they can adjust their level of service so that it's either close to or at the contractually agreed standard. And the advantage of this sort of approach is it obviously encourages the supplier to overachieve for a period of time after having a poor performance. The disadvantage is that it downplays the importance of hitting the service levels each and every month and may not also match the business expectations of having a sustained and consistently high level of performance. And also you need to consider whether you want to have flexibility during the life of the contract, whether or not you would want to have the right to adjust these service levels and the service credits that might be payable, depending on how well the supplier has performed over a period of time. So if you are drafting these sorts of regimes, make sure that you do, from a customer's point of view, include the right to adjust this. And obviously from the supplier's perspective, you would probably want to have at least a period of time after entering into the contract to adjust your processes and performance as your understanding of the customer's requirements and customer's IT environment, for example, becomes better. So finally, what are drafting suggestions for liquidated damages? As I said, they're based on the cases we've looked at. It's important that trying to estimate the possible losses that might occur from a breach is recorded during negotiations. And you should have a copy, for example, of the calculations used. You might even want to include some of those calculations within the contract itself. I don't think that's necessarily essential, but certainly you do want to have some documentation, some record of how the parties have come up with the figures that they've agreed and have set out of the contract as liquidated damages amounts. And obviously, if it's very difficult to do that, you might also want to have some sort of commercial justification for the clause built into that clause itself. And obviously that's a fairly loose and broad concept, but I think the further away you get from just simply having a figure that appears to have been plucked out of the air and included in the contract as an amount payable for a particular breach, the better. In terms of service credit regimes, don't rely too heavily on precedents or what you've used before or what has been included in other contracts. I think it's important that you have service levels and service credits that are appropriate for the services that are being provided, and perhaps avoid having too many service levels subject to service credits. Make sure that suppliers are only focused on really the key service levels that need to be performed, and the key, the most important service levels are the ones where you want the service credits to become payable. And remember, from the customer's point of view, that obviously if you try and over-penalize a supplier, then they're almost certainly going to impose a high risk premium on you as a customer in terms of the overall monthly charges. And on that note, I will hand over to Jonathan, who will look at termination rights.
Peter, thanks very much. Yeah, in this part of our webinar, I'm going to look at termination of the contract, either for breach or for insolvency. I'm also going to look at some of the consequences of termination in certain scenarios and some of the contract clauses that are relevant to termination rights. Starting with termination for insolvency, this raises, to my mind, at least two key questions. First is, what do we mean by insolvency? And second is, what are the consequences of a termination for insolvency? So first, what do we mean by insolvency? After all, the Insolvency Act itself basically provides two tests for insolvency. A company is insolvent if it can't pay its debts as they fall due, which is the cash flow test, or if its liabilities exceed its assets, which is the balance sheet test. So why doesn't every contract simply use these Insolvency Act tests to define insolvency for the purposes of the contract? Two main reasons, I think. First, the Insolvency Act itself uses these two tests for different reasons. And so, for example, a company that fails the balance sheet test may be technically insolvent, but that doesn't necessarily mean it has to go into liquidation. and perhaps more importantly for present considerations, may well not fail in its contractual performance obligations and may be able to continue to perform the contract satisfactorily in the future. Second, and looking at it sort of slightly the other way around, parties are naturally concerned at the idea of being tied to a contract with a company in financial distress, and so often want to be able to terminate their contract at an earlier stage rather than having to watch their counterparty foundering but being unable to take action until some formal insolvency event. So a contract provision called termination for insolvency is often actually shorthand for a clause which gives the right to terminate in a variety of circumstances where there's a question mark over the party's financial status, but without that party necessarily being insolvent. These additional circumstances tend to fall into two camps. There are those which are typically associated with the commencement of an insolvency process, but don't of themselves involve a declaration of insolvency, for example, the presentation of a winding up petition. And then there are those which are not part of a formal insolvency process, but which would still usually indicate a company in financial difficulty, for example, an unpaid debt or the breach of a banking covenant. There are some fairly standard clauses which cover these wider categories of events, and they tend not to be very heavily negotiated, because often, although not always, the termination events will be mutual, and also because it's not very attractive to the counterparty if one party seems unduly concerned at the prospect of its own insolvency during the contract term. However, it can be worth spending some time checking that the listed events are appropriate. For example, the presentation of a winding up petition is something that can take place without any notice being given to the subject company, and it may be that the first the company knows is when the petition is served on it, and so only at that time does it have an opportunity to oppose the petition. So the appropriate contract termination event might be the subsequent advertising of the petition rather than its presentation. The second issue I want to look at briefly in relation to termination for insolvency is one of the consequences of termination, and what I have in mind here is the ability of one party to recover rights or assets from its insolvent counterparty. Let's take the example of an asset which is a copyright work, such as a manual or a software program. Copyright can be assigned for a term less than the full copyright period, and can also be assigned subject to an automatic reassignment in certain specified circumstances, which may include some failure of performance by the assignee. This is commonly known as a turnaround provision. So what if the turnaround event is the insolvency of the assignee, and the assignor has the right to terminate the contract and to reacquire the assets or rights at less than the price paid, or even for free? Can that turnaround right be enforced? Well, the so-called anti-deprivation rule comes into play at this point. This is a common law principle that applies where a contractual provision directly links the loss of property to the insolvency of a particular entity, and where the court determines that the commercial objective of the parties was to remove that property from one party if it became insolvent. The rationale for the rule is that this would deprive creditors of assets that would otherwise have been available to them on an insolvency. This rule should not come into play where the relevant rights are licensed or are proprietary rights only. So the rule should not prevent parties from providing that contractually licensed rights are terminable on the insolvency of a party, or, for example, a landlord from terminating a lease on the tenant's insolvency, because the commercial justification for the termination of rights in those situations is obvious. Nor does the rule apply to a provision allowing a party to buy back assets at market value. However, where there's a contractual assignment which is structured simply to provide that the assignor is entitled to terminate the contract and to require the reassignment of the transferred assets to it on the insolvency of the assignee, then that provision for an assignment back out from the assignee in the event of its insolvency may fall foul of the anti-deprivation rule, depending on its commercial objective. The application of this anti-deprivation rule has long been a source of some legal confusion, which has not been helped by a number of inconsistent court decisions. But the Supreme Court judgment in Belmont Park Investments, also known as the Perpetual Trustee case, laid down the scope of the rule as I've just described it, and that Supreme Court decision is now the reference point for both the anti-deprivation rule and also a related common law principle that parties cannot contract out of the Insolvency Act's statutory basis of distributing assets to creditors in insolvency, which is known as the rule in British Eagle. From the Perpetual Trustee case, it's clear that the commercial objective of the parties is the key factor in determining whether a transaction offends against the anti-deprivation principle. So a successful challenge to an arm's length transaction, which is entered into in good faith and for legitimate commercial purposes, is unlikely even where that transaction specifically anticipates the insolvency of one of the parties. For completeness, I've also noted on the slide the High Court case just a couple of weeks ago with HMRC and the Football League, which also looked at both this anti-deprivation rule and the British Eagle rule, but I mentioned that just to put that case onto your radar. Note also that in the converse situation, which is where there's an absolute assignment with no turnaround or similar provisions, then even if the assignee is subsequently in breach of contract or becomes insolvent, the remedies of the assignor are limited to the ordinary contract remedies, and the assignor doesn't have a legal right to obtain a reassignment of the relevant intellectual property. Key point to bear in mind in all this is simply that insolvency law imposes a number of fetters on the contractual freedom of the parties, and so care is needed if the consequence of a termination for insolvency is intended to equate to putting the parties back into the position they're in on day one. In that situation, the commercial objective and the justification for the specified consequences of termination should at least be referenced in the contract. Next, termination for breach. And it's obviously very common for contracts to provide a right of termination for breach. Most parties appreciate and agree, however, that not every breach of contract should result in a right of termination. And in this, they're supported by the courts. In Rice and Great Yarmouth Borough Council, Mr. Rice, who was a contractor trading as the Garden Guardian, agreed to maintain and manage the council's parks and gardens. Clause 23 of the contract provided that if the contractor committed a breach of any of its obligations under the contract, then the council could terminate the contract immediately. The council did terminate the contract and argued that this clause 23 should be applied literally so as to give it the right to terminate the contract for breach of any of the obligations contained in the contract, unless they were really trivial. The Court of Appeal said that there were two issues to consider. On the one hand, yes, parties to a contract are free to agree that, as regards any particular obligation, a breach shall entitle the innocent party to treat the contract as repudiated. However, and on the other hand, if detailed semantic and syntactical analysis of words in a commercial contract is going to lead to a conclusion that flouts business common sense, then it must yield to business common sense, said the Court of Appeal. So despite the literal wording of Clause 23, on the facts of the case, the Court of Appeal was unwilling to hold that any single breach of any nature automatically gave rise to a right to terminate. In order for any single breach to give rise to such a right, it had to constitute a repudiatory breach, and in coming to that conclusion, the Court was very concerned about the commercial consequences of it reaching the opposite conclusion. So given the unwillingness of the courts to give literal effect to a clause specifying that any breach of any obligation gives rise to a right to terminate, clear language needs to be used, or the various obligations need to be classified as conditions. What do we mean by conditions? A condition is an important term in the contract, so important that even a minor breach of it will allow the innocent party to terminate. But how do you know whether or not a contract term is a condition? Well, ultimately it's for the courts to decide, but the courts will certainly set a lot of store by the parties' own views. In other words, if the parties have expressly stated in the contract that a particular clause is a condition, then the courts will be loath not to follow the parties' own classification. However, you don't commonly see contract clauses divided up into those which are conditions and those which are not. And indeed, the legal meaning of a condition is often not recognized. For example, most of us will talk about terms and conditions of business or the T's and C's without meaning to suggest that we've performed a legal analysis in the document as to those provisions which are conditions and those which are not. I think there are two reasons for this. The first is that breach of a condition allows for recovery for loss of bargain after termination, which is more than you would ordinarily recover and is often not what the parties want to happen. They're not looking to provide a right to recover additional types of loss, but simply to make clear that any breach of the relevant clause will give rise to a right to terminate. Second, it's easy to create confusion in the drafting as to whether some part of the contract is supposed to be conditional on something else happening, or whether that part of the contract is being classed as a condition.